So at this time, your Honor, the state would like to call the mother here in this matter. Ms. Hill, can I get you to state your name for the record?
Yes, Kristen Hill.
And the name of the child or children that we're here in reference to?
The first one is Ehashua Mitchell Jr. The second one is Zaire Hill. The third one is Zyla Hill.
Thank you. And did you hear what I previously read into the record as it relates to this matter?
Yes.
Are you in agreement with those terms that were previously provided to the court?
Yes.
Are you requesting that the court accepts those agreements and make them part of the order today?
Yes.
Buckle up, guys. Today we are diving straight into a tense courtroom drama. Here, the mother is called to the stand, identifying herself and the children, while the court confirms preliminary agreements. The first spark of conflict arises over the children's last name, revealing the delicate tug-of-war between parental identities. This short but crucial segment sets the tone and stakes for everything that follows.
All right, so as it relates to the contested issues, the non-custodial parent appears to make a request for the children's last name to be changed to that of Hill, reflecting his, just one moment. They're requesting that the name change to Mitchell, reflecting his last name. Are you in agreement to that request, or requesting that the children's last name remain as Hill?
The children's last name remain as Hill.
Is there any specific reason why you believe that the children's last name should not be changed to that of Mitchell?
They have not seen him. They do not know him. So that's why I am asking for it to remain as Hill.
All right. Would you be in agreement to the hyphen last name of Hill hyphen Mitchell?
No.
All right. As it relates to the issue of family violence, has there been any issues relating to family violence between you and the other parties to this case within the last 2 years?
No.
All right. Did you previously have a protective order?
Yes.
And when was that, ma'am?
It was way back in 2020.
All right. Are you currently in fear of your safety or your children's safety?
No.
All right. Are you requesting that your information such as your address and telephone number be withheld from the record?
Just my address.
Is there any specific reason why you're requesting that your address be withheld if you previously testified that you're currently not in fear of your safety or your children's safety?
Just from previous issues. I haven't seen him in over 2 years, so that's why I'm not in fear of my safety. So that's why I'm not in fear of anything right now. I have not seen him.
And do you believe that if the non-custodian parent was to be provided your information, that would be an issue for you or the children?
Yes.
And
My
as it relates to the
specific.
All right, thank you, ma'am. And as it relates to the issue of conservatorship, are you requesting that you be named as the sole managing conservator for the children here in this matter?
Yes.
Is there any specific reason why you believe that you and the other party should not be named as joint managing conservators?
Because he has not seen the kids in over 2 years again. They don't know him. He doesn't know anything about them. He doesn't call to ask about them or anything.
The mother addresses sensitive issues around family violence and safety. Her testimony reveals past protective orders, her current fear level, and the reasoning behind her request for sole conservatorship. These minutes are loaded with tension as the court weighs the children's well-being against parental access, highlighting why the mother believes strict oversight is necessary.
All right. And is it your understanding that the father lives in Houston?
I have no clue where he lives.
And are you requesting that there be no geographical restriction as to where you and the children can reside?
Correct.
And as it relates to visitation, when was the last time the father had any visits with the children?
It's been over 2 years.
And would you be in agreement to the father having a standard possession order for a party that lives over 100 miles away, which provides that the father will have 1 weekend per month for visits?
No, I don't agree to that.
And could you explain to the court why you don't agree to the father having visitation with the children here in this matter?
Again, because he hasn't seen them in over 2 years. They don't know him. Even if they were to see a picture of him or anything, they would not be able to identify who he is. He doesn't call to ask about them, check on them, or anything. And like I said, it's been over 2 years. My little girl, she's the youngest. She's 3. And he has not seen her since she was a newborn.
And do you feel that the children not having any visitation with the father simply because they don't know him would be in the children's best interest going forward?
No, I don't. No. I believe they can have visits, just like supervised visits.
And who are you requesting does the supervision?
Either myself or someone in my family, because they don't know anyone in his family either, and that would leave them uncomfortable.
If the court was to order visits, are you requesting that the exchange for the visitation take place at the Grand Prairie Police Department?
That is correct.
All right. As it relates to the issue of retroactive support, are you requesting child support from the past?
Yes.
And you and the other party to this case did not reside together within the last 4 years, is that correct?
Correct.
All right. The state has calculated support from the time frame of December 2021 through June 2022 for the 2 children, in July 2022 through present day for the 3 children. It's calculated support in the amount of $13,265. Are you in agreement to that amount, ma'am?
Yes.
And how much, if any, would you say that the father has provided you with support for the children over that time frame?
Yes, so I previously stated.
Focus shifts to visitation and child support. The mother lays out her objections to the father's access, citing over 2 years without contact and the children's unfamiliarity with him. She also confirms retroactive support calculations. This part emphasizes the courtroom battle between financial obligations and emotional ties, keeping the suspense high as each side stakes their claims.
It was $100, but I went back and looked at all the transactions, and it was $53.
And are you requesting to give him credit for that amount?
Yes.
So are you in agreement to a judgment after the credit of $53 in the amount of $13,212?
Yes.
And would you be in agreement to the father paying that at $175 per month until that is paid off?
Yes.
All right, do you have any additional information that you'd like to offer to the court at this time?
Not at this time, no.
Nothing further from this party, Your Honor. At this time, Your Honor, the state would like to call the father hearing this matter. Sir, can I get you to state your name for the record?
Oscar Mitchell.
And Mr. Mitchell, did you hear what I previously read into the record that was agreed to by the parties?
Yes, sir.
And only in reference to those issues that were agreed to, are you still currently in agreement with those terms?
Yes.
And are you requesting that the court accepts those agreements and make them part of the order today?
Yes, sir.
As it relates to the contested issue, sir, are you requesting that the children's last name be changed from that of Hill to Mitchell?
Yes, sir.
And would you be in agreement to the children having a hyphenated name of Hill-Mitchell?
Yes, that's fine with me, as long as part of my name as well.
And do you believe that the changing of the children's last name would be in your children's best interest?
Yes, sir.
And could you explain to the court how that would be in their best interest to have the name changed today?
Because I know my kids. I've been around them. Mother said what she said. I know my kids. I seen them, but a couple years ago, I haven't seen them because I have no contact with her. Wherever I call her, she blocked me. Never knew her address and all that else sort of stuff like that. So I know my kids. And then I FaceTime here and there.
The father presents his side, responding to contested issues like name changes, conservatorship, visitation, and support contributions. His perspective contrasts sharply with the mother's, showing a parent eager to maintain connection despite practical challenges. The tension peaks here as the court hears conflicting views on what is truly in the children's best interest, highlighting the complexity of family law disputes.
Has there been any issue relating to family violence between you and the other party within the last 2 years?
No, sir.
And was there a prior protective order in the year of 2020 that you know of?
Yes, sir, it was.
And that has expired to your knowledge, is that correct?
Yes, sir.
And do you have the other party's information, such as her address and telephone number?
I just have her cell phone number, that's all.
And are you requesting that her address be provided in the court order today?
Yes, sir.
And as it relates to the issue of conservatorship, are you requesting that you and the other party to this case be named as joint managing conservators?
Yes, sir.
And in the past, sir, have you and the other party been able to make decisions together that are in the children's best interest?
Yes, sir.
And do you feel that that would be in their best interest going forward, that you two work together to make those decisions going forward?
Yes.
And as it relates to visitation, are you in agreement to having a standard possession order, which will provide that you will have visitation once a month with the children?
Yes, sir.
And you will not be in agreement to having the supervised visits, is that correct?
Yes, sir.
And are you in agreement to the exchange to take place at the Grand Prairie Police Department?
Yes.
And as it relates to the issue of retroactive support, the state has calculated retroactive support with a credit of $53, and will request to take a judgment in the amount of $13,212 to be paid at $175 per month until that is paid off. However, you are not in agreement to that amount. Is that correct?
Yes.
And in the time frame that was previously provided from December 2021 until present date, sir, how much money, if any, would you provide that you've given to the mother for the support of the children?
Well, the calculation with everything, I say 3,000. That's with everything.
And as it relates to the $3,000, so do you have any proof that you made those payments to the mother?
No, sir. I don't have the receipts and nothing like that.
The judge delivers the critical rulings. The children's names are officially hyphenated, conservatorship is clarified, and back child support is confirmed. Visitation schedules are set, balancing fairness with practicality. This segment is the climax, resolving months of contention while underscoring the judge's effort to prioritize the children's welfare above all else.
So how did you make those payments, sir?
I bought it at the store and gave it to her.
You brought what, sir?
Clothing, diapers, pull-ups, all that stuff.
And how much money did you provide to the mother directly for the support of the children?
None, because I didn't trust her with it.
All right. Do you have any additional information that you'd like to offer to the court today, sir?
No, sir.
All right. Nothing further from this party, Your Honor.
Okay, the parts y'all agreed to at the beginning, those are all fine. I'm not sure why I didn't do when you had these kids, why you didn't name the kids with both your names. I don't know why y'all didn't do that. You got 3 kids, it's not just 1 kid. So I'm going to do a name change to Mitchell-Hill. So either one of you will need to change the children's last name so that that can be amended in their school records and also for the Social Security office. So you'll have to go down and take a copy of the court order to the birth certificate office for them to make that change. Otherwise, it won't be done automatically. Making a finding there's been no family violence in the last 2 years. I'm granting the mother's request for non-disclosure, so you're not required to provide Mr. Mitchell your address, but you do need to make sure you have a way to contact each other. So we need to make sure we keep the phone available or some other way for y'all to be able to communicate. If y'all live in 2 different cities, then sole managing conservatorship makes sense to me, since y'all can't really work together, even if it's just not the other issues, just because y'all don't live in the same city. Sole managing makes sense. There's no geographic restriction, and the exchange location is fine. If you didn't give her any money, then I can't give you credit other than the $53.
Okay.
So you owe back child support of $13,212 to be paid at $175 until paid in full. As far as visitation is concerned, there's no reason for there to be supervised visits. Y'all chose to have 3 kids with each other. That means y'all trust each other to have kids with each other. And so Mr. Mitchell should have the right to visit with his kids. I know it's going to be more difficult because he lives out of the area, but he should be able to designate 1 weekend a month when he can come up to Dallas and pick up the children in Grand Prairie and visit with them for the weekend. He will need to notify you when that is, and then you'll have to go to the Grand Prairie police office to do the exchange when he notifies you. If he doesn't notify you, then you don't have to do anything, but he'll have visitation 1 weekend per month if he chooses to do visitation, and also a long summer as well, 42 days of visitation. All right, let's see, check my notes. Okay, that should be all our issues. Yes, Mr. Tatum?
Yeah, I just want to confirm with the non-disclosure, are you requesting that the telephone number only be provided, or are you requesting that the parties communicate via app close?
They already have each other's phone numbers, it sounds like, so just need to not block it. And so that needs to be shared. And then I'm granting non-disclosure as to address.
All right, thank you, Honor.
Okay, it's kind of impossible for him to visit if he doesn't know where you live, but you need to have, that's what I'm saying. It's very important that y'all have each other's phone number or some other way to contact each other, because you need to be able to communicate. You chose to be parents of these 3 kids, and so you chose to have this other person in your life forever. So you got to figure out a way, and it's, for the child's best interest, they need to visit with their dad. They need to have communication with dad, even if you don't like it. So we got to figure that out, even though that might be difficult. All right, the Attorney General's office is going to put that all in writing, email y'all a copy of the order if they can, and then that'll conclude our case today. Y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
The judge emphasizes communication between parents, ensuring the children maintain contact with both. Non-disclosure for safety is confirmed, and the courtroom proceedings conclude. This final moment reinforces responsibility, respect, and the importance of collaboration. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.